Hello and welcome everyone. My name is Jillian Bender-Cormier. I'm brand manager with Bender Insurance Solutions. We want to welcome you to another educational BenderU webinar on OSHA's new controversial vaccine rules. Learn what they are and how you need to respond. Some housekeeping notes. At the end of this webinar, we will have an engaging Q&A session that I will be facilitating. If you have questions during the webinar, please feel free to type them into the chat box or in the Q&A section. We'd like this to be an interactive experience, so I'll be sharing our questions with our presenter to answer them in real time. During our dedicated Q&A time near the end of the presentation, I will be sharing additional questions you might have with our speaker. We want to be conscious of time, however, so if we don't get to answer all of your questions, I'm sure there's going to be a lot for this topic. We'll gladly reach out to you individually after the webinar. You're all in listen-only mode and will remain muted throughout the webinar. This session is being recorded. At the conclusion of the webinar, the recording link and a copy of the slide deck will be forwarded to you. We have a fantastic expert sharing with us this morning, but I'll let Bender's own VP of Construction Risk, Edward Johnson, do the honor of introducing him. Welcome, Edward.
Good morning. Thank you, Jillian. Edward Johnson with Bender Insurance Solutions. I want to thank you all for joining us today on this important topic. Bender Insurance Solutions has been providing educational forums and seminars like these for well over 20 years now. If this is your first, welcome. I know it will not be your last. If you're a return attendee, welcome back, and you know what to expect in the next hour. Lots of informative information. I'm not sure how many of you on the call took the time to read through the brief 490-page emergency temporary standard that was released about 10 days ago, but I know today's presenter has. So I have the pleasure of introducing a true friend of our agency, Mr. Aaron Silva with Murphy Austin Attorneys. Aaron is a partner with the Labor and Employment Practice Team. He has an extensive background defending employers before state and federal courts and several administrative boards, including the National Labor Relations Board, the California Division of Labor Standards Enforcement, the California Workers' Compensation Appeals Board, the California's Unemployment Insurance Appeals Board, and Cal-OSH Appeals Boards. Aaron is just one of a few California attorneys with expertise in occupational safety and health law, having formerly served in the Cal-OSH Appeals Board Legal Department. Aaron's prior experience with the California Public Employment Relations Board is also a valuable asset when assisting businesses faced with union organizing campaigns, unfair labor practice charges, and federal injunctions sought by the General Counsel of the National Labor Relations Board. He frequently speaks on labor and employment issues for businesses, employers, and human resources groups. He also performs management training in the areas of avoiding discrimination and other public policy violations, as well as required sexual harassment training for supervisors and managers. Aaron is a graduate of the University of California, Davis School of Law. And one last thing, I do want to plug Aaron's podcast, the HR Legal Podcast. I have always found them timely, informative, and to the point. If you've not had the opportunity to listen to any of these, I highly encourage you to take a listen. And with that, I will turn it over to Mr. Aaron Silva. Aaron, take it away.
Thank you, Edward. I appreciate the introduction. Good morning, everyone. So before we jump into this, I just kind of want to give you an overview as to where I am at as far as with all this COVID stuff. We're on the better part of 2 years of COVID regulations, guidance, laws, rules coming out. It's been very challenging for employers. As Edward said, I do a podcast, a monthly podcast. So that is almost for at least the last 2 years, almost always the topic that I'm talking about. As Edward also said, I am a partner at Murphy Austin. So Murphy Austin is a full service law firm. So we run around 60 to 70 employees. We just don't have labor and employment, which is I'm the chair of that department, but we have construction, real estate, general litigation, probate, things along those lines. The reason that I'm mentioning that is that I don't just practice employment law. So basically anything involving employee stuff is what my practice involves, and I am on the employer side. But because I'm a partner at Murphy Austin and that's my expertise, I'm also in charge of my firm's HR and safety. So when I'm advising people on all this COVID stuff, I really do feel your pain because I'm advising employers about what they need to do, but I'm also in the challenging position of having to implement it for my own employees as well. So I get it both ways, which I think is a valuable asset when I'm trying to implement all this stuff for everyone. So with that background, why don't we jump into this? So of course, we need to do some sort of legal disclaimer. So you're going to get a copy of this later on so you can read it, and I'm sure all of you will thoroughly later on. But before we start talking about the vax rule, we need to step back and do a little civics lesson. So this presentation is going to focus on federal OSHA, the U.S. Occupational Safety and Health Administration. And throughout the presentation, when I use the phrase OSHA, I'm referring to the feds. But I am sure that most of you have heard the phrase Cal OSHA. So what is the interaction between these two agencies and what does it mean for you? This is going to become important now and later on in a few slides. So back in 1970, the federal government approved the Occupational and Safety Health Act, which created federal OSHA. Basically, they were designed to administer safety and health regulations for covered employers. But that act allowed states to create their own state versions of OSHA. But there was one catch. States, if you were going to create your own OSHA system, you have to implement regulations that are at least as protective as what we at the feds are doing. Now, it has to be at least as protective, but it can be more protective states if that's what you want to do. So California was one of the states that created its own OSHA plan, and that's Cal OSHA. So because of that, Cal OSHA has jurisdiction over almost every single workplace in the state of California, not the feds. And not surprisingly, because this is what California tends to do, Cal OSHA is generally more stringent across the boards with the regulations that it implements for California employers as compared to its federal counterpart. Now, as Edward said, my experience back in the day when I was getting my legal legs back in law school was with Cal OSHA. So that's what I consider my home agency. Cal OSHA is split into three parts. It's their standards board. Those are the folks that create regulations. Enforcement, these are the folks that show up at workplaces and issue citations. And then the appeals board, if an employer doesn't like a citation, they can appeal to effectively the Supreme Court of the Cal OSHA system, and that's the appeals board. That's who I worked for. So I worked for them for about 2.5 years, graduated law school. I was a graduate legal assistant there. Graduated law school, became an attorney. They were not hiring attorneys, so I was out on my own, ended up at Murphy Austin, and here we are. So because of that background, there's not a lot of attorneys that do a lot of OSHA practice or Cal OSHA practice. There's about 3 or 4 of them in the entire state. And I'm one of them, and the reason is those people that have a lot of focus with Cal OSHA tend to have come out of that legal system, and that legal system for Cal OSHA is not incredibly big. But anyways, I have always, like somewhat of a jealous ex-boyfriend, I'm always interested to see what Cal OSHA has done, and during these COVID times, they have definitely expanded their authority dramatically. But this concept of federal OSHA versus Cal OSHA is going to become important in a bit. So with that being said, let's jump into a huge overview of what's going on in this seminar. So approximately we're almost, that says months ago, it should say weeks ago. A couple of weeks ago, the White House announced that it was going to impose a nationwide vaccine mandate. On November 5th, Cal OSHA, or excuse me, federal OSHA, released what is known as an Emergency Temporary Standard, ETS. That's an emergency rule, which basically means that federal OSHA didn't have to go through all the public hearings that it otherwise would have to abide by in order to implement this standard or regulation. Now, very broadly, the standard requires that employers with 100 or more employees to develop, implement, and enforce a mandatory COVID-19 vaccination policy and require any workers who remain unvaccinated to undergo effectively weekly COVID testing and wear face coverings if they don't get that vaccination. Now, just a little bit of background. Like I said, these rules got released just a couple of weeks ago. But back in June of 2020, there was a lot of pressure on federal OSHA to come up with some emergency rules to specifically address COVID. And they declined to do that. They said that they had, quote, reasonably determined, unquote, that an emergency standard wasn't necessary to protect working people from occupational exposure to COVID-19. I mention that because that's going to be something important for the legal standing for these regulations. Now, a little bit of background in the last 50 years, so since about 1970, when federal OSHA was created, 10 times they have tried to issue an emergency temporary standard. They were all challenged in court, and out of all of them, only one has actually survived and been implemented after having legal challenges. Now, I will note that federal OSHA didn't do COVID standards back in June, but Cal OSHA did. So they did emergency standards that were implemented November 1st of 2020, so about a year ago, but they got proposed about 13 months ago. So here at the federal or the California side, we've had emergency standards for a while, and they have been challenged and they have been upheld. So point being that the way that the state has approached COVID, seeing that this is an emergency search situation and we need emergency regulations, has been different than what the feds have done until quite recently, obviously, when they've implemented their own rules. So the emergency standard is stayed pending a hearing. So if you follow the news, it was not surprising that several states immediately filed lawsuits challenging the Fed's emergency standard and sought an injunction. So the rule got issued on November 5th. On November 6th, so the very next day, the Fifth Circuit Court of Appeals down in New Orleans issued a stay citing potential grave statutory and constitutional issues. So I'm on top of things, I think. So the rule comes out on November 5th. November 6th was a Saturday, so I was doing an emergency podcast on this very topic. So it takes me about an hour to do that. It was like 9 minutes long, so about 15 minutes to record, and then the rest is editing, putting in music and stuff like that. At minute 57, I got a news alert saying that an injunction or a stay was issued by this federal court, which brought into question, okay, was all this work that I just did for an hour still relevant or not? But I believe that it still is, which is why I issued that and why I'm going to continue teaching this, because as I'll explain in a little bit, just because we have a stay doesn't mean that that's the end of the story, and I doubt that it will be. But anyways, on November 12th, the court, so the Fifth Circuit, reaffirmed its stay pending adequate judicial review of the rule. So effectively, it's going to have to go to a hearing about whether or not this thing is legal or not. Federal OSHA was ordered by the Fifth Circuit to take no steps to implement or enforce the standard until a further hearing can be issued. That court cited several issues with the rule, specifically whether or not this was really an emergency situation in light of a lot of the things that have been said at the federal level. And in fact, as I said before, back in June, OSHA determined that this wasn't an emergency type of situation that needed emergency standards. So what changed in between June and between now? The court also found that the rule's likely unconstitutional. But not for privacy considerations, but because effectively OSHA was taking over the legislative authority that is constitutionally vested with Congress. So those were all temporary findings, so there's nothing final there. There doesn't need to be final hearing. So why are you here? Why am I teaching this, right? There's an injunction against these federal rules. Why are you going to spend an hour with me here on this Tuesday morning? Well, the reason is it's not the end of the story. There have been appeals that have been filed in several jurisdictions, not necessarily just the Fifth Circuit, which is considered one of the more conservative circuit courts that we have in the nation. There's going to be a lottery that's ultimately going to decide, out of all the appellate courts that have jurisdiction over this, which one is actually going to hear this and decide this. So it could go to the Fifth Circuit, which is conservative, or generally considered conservative. It could go to the Ninth Circuit, which is generally considered more liberal. At the end of the day, however, if you're asking me to bet, I think that this is going to end up in the Supreme Court, but I have no idea when that's going to happen. We'll just have to see. The other reason why you're here is because, going back to that civics lesson, Cal OSHA can do its own thing. They can decide if they, okay, well, this is all fights with the feds and whether the federal rule is legal or not, but why here at Cal OSHA can't we do something? And we've seen that they definitely have that view that they want to step in and they want to address COVID head on. So it's very possible that while all this legal fight is happening at the federal level with this federal rule, that Cal OSHA basically uses that federal rule as a base and then expands upon it and comes up with its own rule. So we'll go in a little bit about the timing of what Cal OSHA is planning to do in this, but that's why it's still important. So you need to know this, because at the very least, if OSHA does something, this is at least going to be the base. It would probably be more strict than what you're seeing right here, but we at least know it would be as strict as what we're seeing in this presentation right now.
Okay, Aaron.
So let's actually, yes.
We have a question already. The question is, and you might touch on this, what are the fines if an employer decides to not implement this mandate?
What I saw, it was 14 grand. And it was per violation too. So if you had several employees that were not complying, that 14,000 could build. If it's 2, it's 28, things on those lines. But again, keep in mind that this federal rule at least has stayed for a while. But if it is implemented, that's what I heard would be happening. If OSHA came in and did its own set of regulations, that would be assessed under its own penalty structure. And a serious violation for OSHA is $18,000 as its base. With a general violation, it's less than that, but I can't imagine OSHA doing general, but I'm speaking for them and I haven't even seen their rules. But for the feds, 14 grand. Okay, so getting back, so let's actually step in to see what this regulation is doing. So as far as the scope of the standard, as I said before, it is going to cover all employers with a total of 100 or more employees at any time while the standard is in effect. So that's going to count full-time people. It's going to count your part-timers too. So be aware of that. And it's at any time, right? So if at some point you go over 100 people, this regulation is going to come into play. It does not affect federal contractors and subcontractors. So there are definitely folks out there, because I have read these rules where they are, the construction people out there on this seminar, and know that you're out there. If you're in this situation, if you're subject to the federal contractor or subcontractor rules that came out at the same time a couple of months ago, as when the White House announced that they were going to be doing this vaccine mandate, you're subject to those rules. Also, there are exclusions for certain healthcare facilities who are subject to their own rules, vaccination rules. Also, the standard does not apply to employees, so employees of covered employers. So these are employees who are working for an employer with more than 100 employees. So it's not going to apply to those employees who don't report to a workplace where other individuals such as coworkers or customers are present. So if they're working at at some established location, but they're there by themselves. It doesn't apply to employees who work from home, or it does not apply to employees who work exclusively outdoors, which I'm sure my construction listeners right now, that perk them up, but don't get too excited. So like I said, or as Edward said, the rule is 490 pages long. 17 pages of that are the rule itself. The other pages are all legal authorities and interpretations of those 17 pages. So you can see how concise this thing is. So when I read this, that kind of perked me up, because I knew my construction people were going to be asking me that. But here's what OSHA says in interpreting what that means in the context of the construction industry. Quote, on a construction site, workers inside a partially complete structure are not truly outdoors, and some individuals on a construction site may spend a significant amount of time in a construction trailer where other individuals are present, unquote. So the point being, exclusively means something. It's you are exclusively outdoors. You're not going indoors. So that is our scope. There we go. Contents of a mandatory vaccination policy. So as I said, at the base, that's what this standard is requiring. It's a mandatory vaccination policy, which is an employer policy requiring each employee to be fully vaccinated. Specifically, the policy must require vaccination of all employees, including vaccination of all new employees as soon as practical. So if you're going to bring someone in, you're going to hire someone as soon as practical, they need to comply with this standard. Now, there are certain individuals who are exempted from coverage of a mandatory vaccination policy, and those include people where the vaccine is medically contradicted, those where medically it requires some sort of delay in the vaccination, or they're legally entitled to some sort of reasonable accommodation for a disability or sincerely held religious belief or practice or something along those lines. So what does fully vaccinated mean, and how do you confirm it? So a person is considered fully vaccinated 2 weeks after completing all required doses of the authorized vaccine. And at least the minimum amount of space between the doses has been complied with. So obviously that depends on the vaccine that you're dealing with. If it's the Pfizer vaccine, which is only 1 dose, you're just looking to have 2 weeks lapsed since you got that shot. For the other two, obviously you're going to need to do a little bit of homework. So if you're Moderna, for instance, which is 2 doses, when did you get the 2 doses? You know, was the amount of time lapsed between the 2 doses? I think that's 21 days. And then on top of that, after you got the second dose, has 2 weeks at least followed. At that point, you're considered fully vaccinated. Now, the standard states that an employer must determine the vaccination status of each employee and whether the employee is fully vaccinated. In other words, you can't stick your head in the sand about this. You're actually going to have to ask your employees about their vaccination status. So like I said, OSHA, so we're back on this state, they did their emergency regulations back in October of last year, and they were implemented in November. Now they did a revision of that in June, and in fact, in the month of June, OSHA reversed itself with guidance that contradicted itself. I believe it was 4 times within 1 week, which was a horrible week for me because I was getting plenty of calls about it. But for instance, with OSHA, effectively they created a 2-tier system. So vaccinated employees were treated differently as compared to unvaccinated folks when it came to things like masks, and it came to things like if someone was a close contact, what was the quarantine rules that applied to them. But those rules kind of were up in the air about whether an employer actually needed to ask anyone about their vaccination status or not. The federal rule here is completely different. It is putting an affirmative obligation on employers to ask that question of their employees. Now, in response to that question, you presumably are going to be told that someone is not going to tell you what their vaccination status is, or they're unvaccinated, or they're vaccinated. So this next part here is talking about a vaccinated employee. How do you confirm as an employer that someone is actually vaccinated, fully vaccinated under the definition we just talked about? Well, the employee needs to provide quote unquote acceptable proof of their vaccination status. So what's acceptable proof? Well, it could be an immunization record, a copy of the COVID vaccination card, a copy of medical records documenting the vaccine, a copy of immunization records from public health, state, or tribal information system. I'm vaccinated. I got it through my Indian tribe, or some sort of other official documentation that contains the vaccine that is administered, the dates of administration, the name of the healthcare professional, or clinic sites administrating the vaccine. For my money, I think that the best form of proof is the COVID vaccination card. That's going to have all the information that you need for the definition of fully vaccinated, right? Because that card will show when the doses were administered, so you can see if the requisite amount of time between the doses was satisfied. And of course, it's going to show when the last dose was administered, so you can see if this 2 weeks was satisfied to determine if someone was fully vaccinated. Now, those are the normal ways that someone could go about showing acceptable proof of vaccination status, but there's one other way that you can do it. If all those other reasons, so we'll go back 1 slide, all these other 5 reasons, if an employer for some reason can't provide that information, they can actually self-attest. So effectively, they're telling you that they are fully vaccinated. So how does someone self-attest? Well, there are very specific requirements about what they're going to need to do. So they're going to need to submit a signed and dated document which does all the following here. 1, it attests to their vaccination status, so that they're fully vaccinated or they're partially vaccinated. So you're going to need that information again in that document about, when did they get their doses for a particular vaccine? When was, has the 2 weeks lapsed or not? If that's applicable, that sort of information. The signed document is also going to have to attest that the employee has lost and is otherwise unable to produce acceptable proof. The acceptable proof being, the factors that we just talked about in this slide here, these 5 considerations. Self-attesting is also going to have to include the following language. This is a direct quote, so this is presumably the exact language that is going to have to appear in the signed document. And presumably, if this exact language doesn't appear, then the self-attesting is not going to be valid, and this person is going to have to be considered unvaccinated. But the language is this: I declare or certify, verify, or state that this statement about my vaccination status is true and accurate. I understand that knowingly providing false information regarding my vaccination status on this form may subject me to criminal penalties. There's also guidance in the regulation that says the statement should also include information about the type of vaccination administered, dates of administration, the name of the healthcare professional or clinic sites administering the vaccine. It does say should, but in my mind, I don't know why an employer wouldn't ask this information. Because remember, all of this OSHA stuff isn't being done in a vacuum. There are plenty of jurisdictions that are issuing their own rules and regulations about COVID. So cities are doing it, counties are certainly doing it, and definitely the state is doing it as well. And all of those regulations and all of those rules and all of those laws are creating potential liability for employers. So for instance, here in the state of California, there's now a presumption that if someone got COVID and it was in close proximity to being at work, that is a covered claim under workers' compensation. Now, it's a rebuttable presumption, so if you put up acceptable proof, you might be able to escape that. And if you have workers' comp, there's always a concern that if you get a workers' comp claim, there's something called a serious and willful claim that can be filed in conjunction with that. If you don't know what that is, workers' compensation law says if an injury, an employee injury, is caused by the serious or willful misconduct of the employer, whatever the employee gets awarded for regular workers' comp, they get a 50% penalty. So if an employee is awarded $100,000 for some sort of workplace injury, but it was caused, the injury was caused by the serious and willful misconduct of the employer, then the employer needs to pay in addition to that $100,000, the employer is going to have to pay a penalty of $50,000. And on top of that, that's not insured, so it comes out of the employer's pocket. Now, there's lots of evidence that can go against that, but if you have a COVID outbreak, you're going to want to show that you effectively did everything that the guidance and the rules and the regulations were telling you to do. And one of the things is if you're going to have people self-attesting, so you're taking someone at their word, you're going to want as much information about it as you possibly can show to show that in good faith you were relying on their representations in case that just wasn't the case, right? Maybe someone's self-attesting, but they're just lying about it, right? So you want to show that you took all reasonable steps that you possibly could.
Hey, Aaron.
Documenting.
Yes.
I've got 3 questions for you.
Let's do it.
If you want to go through it. All right, perfect. The first question is from Dawn. They ask, is it anticipated that Cal OSHA will make this rule applicable to employers with fewer than 100 employees?
Dawn, that is an excellent question. So as I said originally, Cal OSHA is required to do what at least the feds do, so as the floor, but they can go more strict. So we know that and by the way, when this rule before the injunction happened, Cal OSHA was going to have to issue their own rule within 30 days of November 5th. So what that means is that Cal OSHA would at least adopt a rule that has 100 employees. But your question, Dawn, is would they go less than that? They have a meeting on the 8th that's going to address that. But if you're asking me what my opinion is going to be, absolutely. I don't see any way that Cal OSHA goes with just 100 employees for a variety of reasons. One of them, in the legal challenge that the Fifth Circuit did when they issued their opinion, they specifically said, hey, federal OSHA, if this is an emergency, and we need to protect all employees in the workplace, why is this rule only applicable to employers with more than 100 employees? If it's such an emergency, shouldn't it apply to everyone? So I think Cal OSHA is going to be receptive to that. I have sat through some of the Cal OSHA hearings. Back in June, when they reversed themselves, I think 4 times in 1 week, those meetings were running on average 6 hours, and I think the longest one was 10. Now, I'm not going to say that I sat through all of them, but I sat through most of them. And those board members, that's the standards board for Cal OSHA, they were reflecting this sort of sentiment that we need to be very strict. We're not out of this pandemic. So yeah, I definitely think that they're going to go less. I don't know what that number is going to be. If it's going to be 50, it's going to be 25. quite frankly, I think it's going to be less than that. And here's why. If you look what the governor did with schools, if you have a child that at this point is 5 years old or older and they're in public school, and by the way, this I'm paraphrasing, I'm not an expert on this particular part, but I am a parent. So I'm just telling you what I know about that rule just from what I've read. But Newsom basically said that for kids in public schools, they're going to have to get vaccinated. That's just not for public schools, that's for private schools too. And as I read it, there was not a carve out, at least from what was announced for kids, for like medical exemptions or sincerely held religious beliefs. Instead, if you were one of those children that needed some sort of accommodation, or you just refused to get vaccinated, it wasn't that you showed up and you got tested, or you wore a mask, which is something that does exist for this federal rule. It was you homeschool. For a lot of parents, that's just not practical. But my point being is that the state has been very strict. So I think definitely when OSHA gets around to doing this, it's going to be less than 100 employees. And it's one of the reasons why if you have less than 100 employees and you're on this webinar right now, you need to really perk up and listen to this stuff, because I think it's going to come for you. Now, I don't know if that is a minimum number of 5, 25, 50, or it's just if you have any employees, but it's going to be something less than 100. So question 2.
Great, thank you. This question's from Mario, and he asks, will you be going into more detail on exemptions, what they are and how it can impact employment?
I wasn't planning on it, but if you have a specific question about it, go ahead and submit it and we'll take it.
Okay,
Question
perfect.
3.
And then from Rebecca, this is kind of a multi-part question. Can an employer require a certain type of acceptable proof, or is it the employee's choice?
It is not necessarily the employee's or the employee's choice. There's nothing in the regulation that specifically says that one way or the other, or any of the guidance that I saw. Presumably, I don't see why an employer wouldn't be able to do that. I mean, they always, whenever there's several options that are presented to an employer in a regulation, you always possibly run afoul of some sort of legal challenge if you refuse to do that. But at the end of the day, if you decide that you don't want employees, for instance, to self-attest, like I said, I did not initially see anything that indicated that you couldn't do that. But if you don't want them to self-attest, you're going to have to treat them as unvaccinated, right? And like I said, if we're going to get to a few slides here about what you do with unvaccinated individuals, so you would just need to follow those rules. So to answer your question directly, I didn't see anything that said that you couldn't, or you could, or you couldn't do that. But at the end of the day, if for whatever reason you don't accept proof, or they don't accept, or the employee doesn't submit proof about vaccination status, you're just going to need to comply with the testing and mask rules that we're going to go into in just a few slides.
Perfect.
Thanks,
The second part of her question was related to workers' comp. If an employee gets vaccinated as a result of the mandate and has an adverse reaction, is that a workers' comp claim?
Not necessarily. I didn't see. So this is one of those situations where state law has not caught up with federal law. It's a question that I have seen posed. I have not seen any agency actually give guidance on that. I'll tell you what my hunch is going to be. My hunch is no. And the reason is because the government would effectively be requiring this. So it's not an employer requirement, unless an employer goes out and individually, well, let's say that an employer says, okay, well, I'm going to implement this plan right now. Before we actually have legal requirements that they be in place. In that situation, I could see that happening, right? Because no one's telling employer that you need to implement a mandatory vaccination rule. And if you're requiring employees to then comply with that rule, and someone has an adverse reaction to it, and it's to the level that someone actually would file a workers' comp claim, I could see that being a viable claim. I haven't seen guidance saying that one way or the other, but I definitely could see that as being a viable claim. However, if we wait and we now do have an enforceable rule from federal OSHA and its counterpart Cal OSHA, and effectively the only reason that an employee is getting vaccinated is because federal law or state law is requiring to do that, I see that as being an employer defense. So with that in mind, that might be a consideration for you employers that are considering effectively jumping the gun here and just getting a start on doing these mandatory vaccinations pending government approval. So was that it with questions?
Well, we received one more, and
Do it.
we can make this the last one just for a little bit so you can get on with your
That's fine.
presentation. But this one is from Carrie or Kari. I work as the HR manager of a home health company. So all of our clinicians, we are following up on to make sure they adhere to the vaccination standards. But do our office staff have to as well? We only have about 20 to 30 office staff.
Well, assuming that you're covered by this, and I know with healthcare they have some um, specific rules to the healthcare industry. But yeah, I mean, under this rule, it would be everyone, right? And unless you implemented some sort of plan, which we'll talk about in a little bit, where if someone doesn't get vaccinated, they do regular testing and they wear masks. So, okay, let's jump ahead. Documenting. Okay, I think that's where we're at. Let's do it. Okay, so documenting vaccination status. So now you've gotten your proof, you've gotten your COVID card, self-attesting, whatever it might be. You have to maintain that record for each employee's vaccination status and preserve the acceptable proof of vaccination for each employee. So this means that you actually need to keep a copy of the card. You need to keep a copy of the immunization record, whatever it is, but keep in mind that that's a confidential medical record. So for my HR people out there, you should already know this, but that means you don't keep it in the personnel file. That is a separate document that gets kept in a locked file cabinet. So it's completely separate. Employers also must maintain a roster of each employee's vaccination status. So you're going to need to know who's vaccinated, who's not, and write it on down. You would want to be doing that anyways. And the reason you'd want to be doing that anyways is because if you have someone who is a close contact with someone who has COVID, or you actually have a COVID case or a COVID outbreak, you're going to need to quarantine certain people or potentially quarantine certain people. And the only way to know who you quarantine is to know who's vaccinated or not. Because obviously, like I said, under the OSHA rules, for vaccinated people, if they're a close contact to someone that had COVID, they don't necessarily need to quarantine unless they have symptoms. The rules are completely different for unvaccinated people. So this is information that you would have wanted to have anyways. This is the feds catching up kind of to the state. Now, the records and roster are considered confidential medical information, as I told you, and this information needs to be maintained and preserved while the standard remains in effect for however long that might be. So how an emergency standard works is that it gets implemented for a certain amount of time, and then it's decided whether or not that's going to be extended or it's going to become a final rule. OSHA is in the process of doing that with their own COVID rules that they adopted back in October of last year, of extending that out, which I would fully anticipate them doing. Okay, so leaves of absence to support employee vaccination. So there is now protected leave. So there's lots of protected leave out there. For those of you that have more than 5 employees here in the state of California, last year, you're now subject to the California Family Leave Act. And if you don't have that addressed in your handbook, you should talk to an attorney that knows how to put that in there for you, because that is a very complex law. But that is a good example of a protected leave. Someone can take that if they have a serious health condition, and effectively you can't retaliate against them because they took that leave. There's lots of protected leave out there. Jury duty, obviously medical stuff if someone is a victim of domestic violence, but this is a new category of protected leave, presumably. So there's protected leave for people that are getting vaccinated. So there's 2 types. An employee must provide under the regulation, quote, a reasonable amount of time, undefined by the way, unquote, for employees to get their primary vaccination doses, right? So if someone says the only time that I can go and get vaccinated is during working hours, you're gonna need to give them a reasonable amount of time off to do that. Now, this portion of the regulation is somewhat specific. It says employees are going to get 4 hours of paid time. Note that, paid time, including the travel time to go get their dose at the employee's regular rate of pay. Now, this does not, address, and it does not apply to when an employee goes and they get their doses on their own time. So it's on the weekend, it's before work, it's after work. This is only when they're getting their vaccine during working hours. So that is protected leave for getting vaccinated. There's also protected leave for recovery time. So now someone has got their dose and they are, having an adverse reaction to that, whether that's minor, whether that's severe. It's common, when I got my second dose, I know that I was not feeling well for about a day, so I just hung out in bed. So it would cover that sort of stuff, or and obviously a much more significant type situation where there's a more harsh reaction. But for protective leave for recovery time, the employer has to provide, once again, a reasonable time and paid sick leave to recover from the side effects experienced from getting a dose. Here's the problem. It's unclear what paid sick leave is in this context, right? So we know for protective leave for getting vaccinated, what is it? It's 4 hours because it tells us it's 4 hours. But protective leave for recovery time, it doesn't tell us what the paid sick leave is. So all we get is a little bit of guidance from OSHA in the other 470 odd pages that are not the rule. And it states employers may require employees to use paid sick leave benefits otherwise provided by the employer to offset these costs if that's available. So presumably that's going to cover PTO, it's going to cover paid sick leave under California law. You can use that. But unfortunately, I just don't have that number that I can tell you that it's 4 hours of paid sick leave that they're going to get for recovery time. I just don't know because it hasn't told me. I would imagine that federal OSHA is going to probably clarify this at some point. Okay.
Aaron?
Yes.
We have a question from Cheryl. She says, and what if they don't have sick leave benefits available?
Yeah, then you're going to have to provide it. You're going to have to pay for it yourself as an employer. So this would be a new requirement.
Okay. And
All
then
right.
final question from Joe. Do we automatically give the pay for vaccination and recovery, or does the employee need to ask?
It's not as specific as that. Presumably, a diligent employer would probably ask. But it doesn't say one way or the other as far as an affirmative request. There were some California laws that required an affirmative request for a particular type of leave. You saw with California's paid COVID leave that expired back in September. There was some affirmative, because that was a retroactive law. So if an employee had an entitlement to COVID leave before the COVID leave law was actually passed, it was retroactive, so they had the ability to get it, but they had to actually affirmatively ask for that. This regulation doesn't say that one way or the other. So I would think that an employer would just need to take some diligent good faith efforts to inquire of that. Obviously, if you know that an employee is getting, vaccine dosage and then the next day they're out, usually they're probably going to tell you, right, why they're out. Most employers would require some sort of form of notification, so that would at least put you on notice. So usually the standard is you knew or you should have known with reasonable steps. So that's the way that I would approach it. Thanks, Joe. Okay, so alternatives to mandatory vaccination policies. So we just talked about a mandatory vaccination policy. What if you don't want to do that? So covered employers, so these are my employers with more than 100 employees, you don't need to implement a mandatory vaccination policy if alternatively they implement a written, and I want to emphasize that a written policy allowing any employee not subject to a mandatory vaccination policy to do, and then we'll talk about it in a second, but let me go back and go on a tangent. Written. Any of the policies that you're doing under this rule need to be in writing. One, the regulation requires it, and two, when we talk about information that needs to be distributed to employees, it includes the policies that the employer is actually adopting that needs to be given to the employees. So this needs to be in writing. Doesn't need to be huge, but it does need to be in writing. So be mindful of that. So you don't want to do a mandatory vaccination policy. I have a feeling a lot of employers are going to be in this situation. What do you do? Well, you do still have to do a policy, but this is effectively the regular testing policy. So let's go over it. This alternative policy, it's going to have to do a couple of things. One, it is going to have to allow an employee to choose to be fully vaccinated against COVID. And provide proof of regular testing. So as far as being fully vaccinated, what an employer cannot do is say, hey, I'm not going to require mandatory vaccinations, and in fact, I'm not going to let you get vaccinated. You're just going to have to be tested on a weekly basis. No, the policy, this alternative policy, you have to allow the employee to have the ability to get to get a vaccination if that's what they choose to do. You can't prevent them from doing that. But that's not what most of this policy is. It's about the alternative to getting vaccinated, which is regular testing. So that's the second part here, right? The alternative policy has to allow for proof of regular testing for COVID for those that are not getting the vaccine. And for those who are not vaccinated, they have to wear a face covering if they're unvaccinated, unless, and there's a few exceptions here, the employee is alone in a room with floor to ceiling walls and a closed door. So not just a door, but a closed door for a limited time while an employee is eating or drinking at the workplace, or for identification purposes in compliance with safety and security measures. They don't have to wear a mask. When an employee is wearing a respirator or a fully covered face mask, where the employer can show that the use of a face covering is unfeasible or creates a greater hazard that would excuse compliance with this particular section here. So for the most part, if someone's not vaccinated, they're gonna have to get tested. They're also gonna have to wear a face covering. Just be mindful, an employer has an affirmative obligation. If they see a dirty mask, they need to have the employee have one that's clean. If it's not being worn properly, the employer has an affirmative obligation to advise the employee that they need to wear it properly, things along those lines. So, and then, you know, for the eating or drinking exception, it really needs to be that the employee just has their mask off for that particular amount of time that it takes to accomplish those tasks. Right, so just if someone has a bottle of water by their desk all day, that doesn't necessarily mean that they're drinking for purposes of an exception to this face covering rule. Now, I would note that there are certain jurisdictions here in California that have their own face covering rules in place. Sacramento County is one of them. So the exceptions are somewhat different than this. So obviously you would go with the more strict of the two guidances, whatever you're getting, whether that's this federal OSHA or Cal OSHA rule as compared to what the county is doing. But obviously that depends on when we get these rules actually implemented. So what's acceptable testing? Like I said, the alternative policy is you actually wear a face mask and you can get regular testing. So there's two standards. Standard one, it's an employee that goes to the workplace where others are present at least once every 7 days. So these are the people that come in, you know, a couple times a week or whatever it might be. They need to get tested at least once every 7 days and provide documentation of the most recent test no later than the 7th day following the date on which the employee last provided a test result. The standard two is for employees that are going to be somewhat, you know, are going to come in less frequently, but they're going to come in nonetheless. For those folks, they need to be tested within 7 days prior to coming to the workplace. And again, they have to provide documentation of that test result upon returning to the workplace. Now, this is an important thing. This is somewhat different than what the state is doing right now. So we'll see what Cal OSHA does to reconcile this. But right under these federal rules, employers are not required to pay for the cost of testing. So if someone chooses not to get vaccinated, and under your policy, you're requiring vaccinate or you're requiring testing and you're requiring face masks, you don't have to pay for that testing. This is effectively a sin tax as far as I can tell, because this is entirely different than how the state has been with COVID. They have tried to push as many costs over to employers as they possibly can. With the feds, they're basically saying employees pay for this. And I'm sure the reasoning behind that is that the employees at a certain point get sick and tired of having to pay for a weekly test or a regular test. And they just decide, hey, I'm just gonna get vaccinated because that's the easier thing to do. Again, employers have to maintain a record of each test provided by each employee, or any tests that are actually conducted by the employer if you choose to do your test yourself. Once again, these are confidential medical records, so they need to be kept in that secure location that is outside the president or outside of the personnel file. And again, the records need to be maintained for the duration of the standard's life.
Hey, Aaron.
Yep.
A quick question from Josh. He's asking, are the at-home tests acceptable?
Josh, that's a fantastic question, and I was debating on whether I was going to do a slide on that or not, but I did not do a slide on it, but I will answer your question. Okay, so what the regulation says is that the at-home tests are not acceptable unless they are the at-home tests are done, and there's certain tests that are approved or not approved, but unless the at-home test is done in the presence of the employer and the employer is the one that is reading the result. So effectively, you would have to have your employee purchase the at-home test, or I guess as an employer, you could do it yourself too. The employee would have to come to the workplace, and you would have to observe them administrating the test, and then you would have to read the result, and then obviously document it for the documentation retention rules that are addressed in the last bullet point of the slide that is currently on the screen. So, but otherwise, an employee just doing it at home and saying, okay, I did this self-test, here's the results, whether verbally or they're actually showing you the result, that is not going to suffice. They would actually have to come into the workplace, and the employer would have to be involved in that process. Thanks, Josh. Okay, so removal from work for positive cases. So this is when someone has COVID, regardless of vaccination status or any COVID testing procedures, the procedures we just discussed. The employer must require employees to promptly notify them when they receive a positive COVID test or they're diagnosed by COVID by a licensed healthcare professional, and immediately remove from the workplace any such employee until the employer receives a negative result of a COVID NAT test, meets the return to work criteria in the CDC's isolation guidance, or receives a recommendation to return from work from a licensed healthcare provider. I want to emphasize these standards for returning to work are not the standards that currently apply in California. So this is one of those situations where Cal-OSHA's rules are different from the feds. So for Cal-OSHA's rules, it's not, okay, you're positive, you give us a negative test, you can come back to work. That is not how Cal-OSHA deals with this at all. Cal-OSHA deals with it is you need to, depending on what your vaccination status is, you need to quarantine for a certain amount of time. Your symptoms need to have subsided, and you cannot have had a fever, or you cannot have had, could not have taken a fever reducing medication within 24 hours of not having a fever, right? So basically the fever needs to have gone away on its own, and you're not taking medication to keep it down. And those standards are constantly changing. At a certain point, the quarantine time is 14 days, and then it went down to 10. That guidance is coming from the state's public health department, and then Cal-OSHA has implemented it. So this is a good example of where the federal rules are different than the Cal-OSHA rules. So going back to the question about, do I think Cal-OSHA is going to be different as far as how many, the covered employer definition for 100 or more employees? Yeah, and this is another area where I expect it to be different too, the return to work rules that exist. Okay, so information that employers need to provide to employees. So under the federal standard, there's a certain amount of information that you as an employer have an affirmative obligation to provide to your employees. The first one being the requirements of this standard. So if it was me, and it will be me, because like I said, I am an employer and I need to do this for my own 60 some odd employees. I'm just going to provide them with a copy of the standard. So a copy of the rule itself. So the second part is the requirements of the standard, as well as any employer policies and procedures established to conform with the standard itself. So I'm giving my employees a copy of the rule. I'm giving my employees a copy of the ultimate policy that my firm ends up implementing as a result of whatever standard we ultimately end up getting. The second thing that you need to provide is information about the vaccine's safety and its benefits, specifically by providing the document, and then key things to know about COVID-19 vaccines. And I give you the actual link. It's a specific document, so you will need to go on the website, assuming that Cal-OSHA, when it adopts its version of these rules, uses this document, but you'll need to print that thing off, and you'll need to give it to the employees, probably with the standard and with the policy. You're also going to have to give information to employees about the requirements of effectively the anti-retaliation provisions of the the federal OSHA Act. So effectively prohibits an employer from discriminating against an employee from exercising their rights under the standard, or effectively anti-retaliation provision rights as exist for filing just a report of work-related injuries or illness under the federal OSHA Act. And then the final thing is the prohibitions from a couple of standards, or a couple of laws, I should say, which provide for criminal penalties associated with knowingly supplying false statements or documentation, right? So that's getting at employees don't give us a fake COVID vaccination card. You could be criminally prosecuted for doing that. So the way that I would approach this, and the way that I will approach this as an employer, is I'm going to probably do a memo to the employees, which that's how I'll address these anti-retaliation and anti-discrimination provisions. I'll attach the specific documents from the CDC that's being required under the standard, along with the standard itself and the policy that ultimately gets adopted by my firm.
Hey, Aaron.
Availability of yes.
Sorry, couple
No, that's
questions for
fine.
you.
Nope.
Our first one is from Christine. She asks, if your files are digital, can you use your payroll software to house the COVID proof of vaccination and test results, or is that seen as keeping with personnel files?
It needs to be secure some way. I mean, the whole point, now we have jumped over to California law. So this is effectively a California law about how you deal with confidential information. You just need to have some way that an employee wouldn't otherwise access it, right? So it needs to be secure. So that's why I'm saying the best practice, if you're actually keeping hard paper copies, is to separate confidential medical information from the personnel file. That way someone just doesn't accidentally come across it and it's locked. If you can come up with some sort of secure digital way to isolate medical information, including the information that we discussed during this webinar today, that's fine. So, but you know, obviously I don't necessarily know your program or what your payroll software looks like, but if you're able to accomplish that task, so it is secure and it's not something that just is generated when you're looking at a regular personnel file search, that would be fine.
Perfect. Another question from Joe. Can we discipline an employee if they knowingly come to work when sick and they know an immediate member of their family is positive for the virus?
Definitely yes for the first one, assuming that they know that they're sick, right? And same for the second too. The way that you're going to address that situation is it's going to be your policies and procedures about what are your employees supposed to be doing. So, you know, we got guidance from several agencies, you know, with it when COVID popped up, you know, that you should be advising your employees that if they're sick, don't come to work, immediately notify us of that, and exclude them if they are sick, or quarantine them for the appropriate amount of time. If an employee is doing something that is prohibiting you from effectively implementing your policies, you can take disciplinary measures. Now you got to be somewhat strategic with it, right? So yeah, maybe it's you suspend them for a certain amount of time. You do a write-up, whatever you might want to do. But let's say we have an employee that actually has COVID. They're going to need to be quarantined for a certain amount of time. But you'd have to strategically look at what sort of discipline am I going to do if they didn't tell me initially. Is it just the write-up? The reason being is, remember, these laws don't exist in a vacuum, right? So let's say you fire that person. They came to work, they didn't tell you about COVID, so they put other employees at danger. But if you fire them, they might come back with you for a retaliation claim, a disability retaliation claim, or saying that I was discriminated against because of a disability. Now, I'm not saying you wouldn't win that lawsuit at the end of the day. I'm just saying that that is a potential that's out there. So you have to be somewhat strategic and take a look at really what are the facts and circumstances, in determining what is the appropriate amount of discipline that I'm going to do. And, I apologize because as an attorney, I always had to throw in the line, you probably should consult with competent counsel too, to see what you can do. Thank you, Joe.
Yeah, of course. And I think for the remainder of the questions, I'll just wait until our Q&A time, just so we can be conscious of time.
Yeah, we are almost done with the slides here. So just availability of records. So just like with personnel files and payroll records here in California, those records, if an employer requests them within 21 days or 30 days, depending on what the request is, you have to produce them. Very similar to what this federal rule is doing. So with all these records pertaining to vaccinations and COVID and things along those lines. So availability of records under this standard, employer has to make it available for examination or copying. That particular individual's vaccine documentation and any COVID test results that you have That's due within the next business day of the request. That's a request that comes from the employee themselves or from their authorized representative. That is not, hey, I want to know what, my coworker, what their vaccination status is. That's just employee specific. Two, the employer needs to make available to the employee or authorized representative the aggregate number of fully vaccinated employees at the workplace, along with the total number of employees at the workplace. That's due within the next business day. Obviously, you can do that in a confidential manner. So you're not going to give the roster that has everyone's vaccination status on it, but you can say, this is how many total employees we have, and this is how many employees are vaccinated or not. And then the employer needs to provide effectively to the government for examining or copying. So when I say government, this would probably be OSHA that would be requesting those records. The employer's written policy and the aggregate number and total employee stuff that we just talked about. This is due, interestingly, within 4 business hours of the request, right? So that is a very short amount of time. So have that stuff available. And then all other records or documents you need to provide to OSHA if it's requested, and that's due within the end of the next business day. Okay, so let's see, I believe we've only got a couple more. So what's Cal OSHA gonna do, right? So they're gonna be meeting on November 18th. So that's just a couple days from now. One of the things that is on its agenda is an item for discussing federal OSHA's emergency temporary standard, which is what we just talked about for about the last hour. And draft regulations for Cal OSHA will be posted on their website as soon as feasible. I don't know what that means. As some of the questions indicated, I expect that Cal OSHA is going to be more strict. I don't believe the standard is going to be 100 employees. It's going to be much less than that. I just don't know what it is. And remember, those federal lawsuits are not necessarily going to prohibit Cal OSHA from doing what it wants to do. So I could easily see Cal OSHA deciding we're going to go ahead and issue regulations now, and we're not going to wait for the feds. But again, that is all speculation. So what do you need to do as an employer, right? Well, obviously you need to keep aware right now the legal proceedings involving the federal rule, because if the federal rule is allowed to be implemented, then Cal OSHA is going to have to implement their own rule. But also independently, be aware of what Cal OSHA does. Like I said, they are meeting in just a couple of days. So we're going to have some guidance here. If you reach out, next slide has my contact information, or there's contact information for me. We'll put you on our email list, and I can guarantee you we're going to be doing an email blast as soon as if Cal OSHA makes some sort of significant announcements on November 18th. So but obviously that's something that you can track yourselves. So I'm sure it's something that will hit the news. But you can always go to Cal OSHA's website because they'll post that information, or you can sit through the meeting, which I would anticipate is going to last from about 6 to 10 hours, and I'm not exaggerating there. Okay, other thing, ensure that you are continuing, or if you're not doing it, start to comply with Cal OSHA's emergency rules from last year, right? And the most significant one of those, and if you don't know anything about that, these are the rules that I've been talking about that Cal OSHA implemented back in October, took effect in November. They are 21 pages single spaced. And the most significant part of that, although all of it is significant, but the most significant as far as I can tell, because it's a document you need to generate, is a COVID prevention program. Right there in that, in the rest of those bullet points there, those are the things that your COVID prevention program needs to specifically address. If you don't have this plan in place, get it in place. So you can do that a variety of ways. You can, of course, reach out to an attorney to do that, or your HR consultant. You can also go to Cal OSHA's website, the Division of Occupational Safety and Health, and they have a model COVID prevention plan where effectively you fill it out yourself. They do most of the work and you fill it out. If you're not going to do anything else, at least do that. Because if Cal OSHA ever comes out and visits you about this stuff, they're going to ask for your IIPP first, and then they're going to ask for this document. So make sure you have both. So that's what you can do right now. There's my pitch for my podcast. It is always under 10 minutes. It's usually under 6. It's once a month. It's just something that, it's an employee topic that I think is going to be of interest of my listeners. So I did an emergency podcast on this particular topic that we just went over a couple of weeks ago. Usually it's just once a month. And like in November and December, it's going to be about new laws that are coming into play for 2022, for instance. So if you're interested, you can reach out to me. But there's also the link to it if you want to see it. But if you want to get on that mailing list, let me know. And then Murphy Austin does do a very comprehensive, about 3-hour seminar about new laws that are coming into place each year. And this year it's by Arden Fair Mall, and it's on December 8th. So if you're interested, please let me know, and we can get you all signed up. But besides that, there's the questions. So what do we got?
Fantastic. Okay, we just have a couple that have come in that we weren't able to address. If Cal OSHA, this is from Rebecca, if Cal OSHA comes out with their own standards, will employers need to comply with both Cal OSHA and OSHA in areas where they differ, or just Cal OSHA?
Just Cal OSHA, because, and here's why, because Cal OSHA is at least going to be as stringent as what the feds do. So the feds are setting the floor for Cal OSHA. And then Cal OSHA will come in and at least do that, but likely do more. Like I said before, Cal OSHA is the agency that covers almost all workplaces in California. And like I said, you know, I practice in front of that board all the time. That's my old home board. I almost never look when I'm practicing in front of them to what the feds are doing for OSHA stuff. I'm always looking to Cal OSHA. So it's the Cal OSHA rules that's the thing that you're going to be implementing.
Perfect. Another question from Mario. If an employee opts not to vaccinate and does not want to pay for their own weekly tests, what recourse does the employer have, and is the employer at risk of being sued for wrongful termination?
Possibly. What you would initially want to do is see if there's any other reasonable accommodation that you could provide to the employee that would get them out of the standard, right? So if you went, I'm sorry, 3 or 4 slides back in, I said for employees you know, employees of the covered employers, there's certain classes of them that don't need to comply with those rules. So one of them is if they work in a workplace where there's no one else present. So I don't know if that's a practical solution for you or not, or if they work remote, you know, if you can allow them to work remote. But at the end of the day, I would deal with that reasonable accommodation situation, kind of like you would deal with a reasonable accommodation situation for a disability, or you would deal with, you know, sincerely held religious belief. Listen, if it's just not practical and they're doing a job that just cannot be done at work, then yeah, you're going to have the tough decision of whether or not, you know, you guys go your separate ways, you know, and you make that decision. Is there a risk for a wrongful termination lawsuit? There's always a risk for a wrongful termination lawsuit. I always say you can be sued for anything that you want to, right? Someone can file a lawsuit saying that they don't like, you know, the tie that you're wearing, or, you know, the breakfast cereal that you provide in your lunchroom. That doesn't necessarily mean that there's illegal, and doesn't mean that you're not going to win the lawsuit, but you can be sued for it. So it's a situation that you need to approach with caution. And again, I apologize, but I am an attorney. That's one of those situations that you probably would want to reach out to competent counsel for some advice.
Perfect. Thank you. Another question that we have, are employees permitted to know who of their coworkers are vaccinated, or is that confidential as well?
Yeah, not specifically addressed by this rule, but the answer to the question is no, they are not allowed to do that. We get that guidance from several other agencies that we didn't address today. For instance, the California Department of Fair Employment and Housing. They're the state department that addresses our equal employment opportunity laws. So Fair Employment and Housing Act, FEHA. Also from the EEOC, that's their federal counterpart. And actually, Cal OSHA did put out guidance when they put out their own emergency regulations back in November. That no, that is a confidential medical information. So even if someone got, you know, sick with COVID, and you're trying to determine who was exposed to that person, the restrictions on it are so strict that you can't say, hey, employee, you know, Joe or Sally came into work and they are now positive for COVID. When was the last time that you interacted with them? You can't do that, because by making that communication, you're telling the employee that Joe or Sally has COVID. You're not allowed to do that. That's confidential information. The way that you approach that situation is, instead you ask Joe or Sally, who are you exposed to, right? You know, for, you know, 15 minutes or more within a 24-hour period during the time that you were in your high infection period. So to answer your question, employees want to know that information, who's vaccinated or who's not vaccinated, but you have a very strong legal basis to say, sorry, employees, that's confidential medical information and you're not entitled to know it. It would be akin to opening up that file cabinet with all that confidential information. And of course, you're not allowed to do that.
Perfect, thank you. And just a reminder, we are recording this. We will be sending out the slides. We'll probably wrap up. We won't go past 9:45 just to be conscious of time. So if we don't get to answer all of the questions that are coming in, we'll connect with you after the webinar. Another question from Lindy, Aaron, how do you count your number of employees? Do you count contract labor?
Yep. Yep.
Okay.
The only one that I saw that was somewhat different was for temporary employees. So, you know, it depends on what your contract labor actually looks like. But for temporary employees, there was some suggestion that those numbers were counted towards the temp agency and not necessarily to the employer. But otherwise, anyone else that you have, you know, you're going to want to, you know, they're going to be counted towards you, and that's part-times too. The other thing that you need to be mindful of is, remember, it's the feds here with the temporary employee stuff. Maybe that doesn't count for this particular regulation, but for a temporary or contract employee, you are a joint employer for all this stuff. So if something bad happens, you know, and the employee is going to be suing someone, they're going to sue their temp agency and they're going to sue you as the client as joint employers. So just be cautious of that. So maybe this isn't something that you know, based on at least these federal rules, are going to apply to you, but maybe you want to. I will put in a little commentary here. I do fully expect that when OSHA does their rules, that your contract employees are going to count to you towards you. Not positive, but that's what my hunch is, because that's what they typically have done.
Perfect, thank you. A question from Mariana. I thought the new law Governor Newsom signed was said that it was the responsibility of the insurance carrier to pay for testing.
Well, exactly. That's where you see differences between these different laws, because they're coming from different regulations. For the most part, if it was testing that was required by the employer was having to pick up that cost, here in California at least, right? So if you had an outbreak at work, there were certain testing requirements that kicked into play depending on how big the outbreak was, and that was coming under OSHA's emergency regulations. Employers were required to pick up that cost, but that's a state rule, right? This is a federal rule. So the federal rule is that the employees are going to be required to pick up the cost. Like I said, I think it's a sin tax effectively. So I think that when this filters down to OSHA, we'll have to see what it says, but I would imagine that this is one thing that I do think that OSHA is going to align with federal OSHA on. If employees, you don't want to get vaccinated and you're going to go the testing route, you're going to have to pick up that cost.
Great. We have a question from Carrie. For our healthcare company, our schedulers need to know who is vaccinated or not for scheduling purposes. How do we handle that?
Depends on who it is. Like I said, for certain healthcare industries are exempt from a certain amount of these rules. If you're just talking like a customer or a client or something along those lines, I mean, this is something that I deal with like at my firm, right? I mean, I know which of my employees are vaccinated. I don't necessarily know if a client who's coming into my office is vaccinated or not. That's just an inquiry that I make at the beginning of whatever meeting that might be, and then you take the appropriate measures based on what that person's response is.
Wonderful. Okay, well, we've got a lull in the questions, so I'm going to go ahead and wrap this up, but we know that questions will arise after we've ended the webinar. So please reach out to us. We're here to help. And thank you, Aaron, so much for sharing with us today. I think we can all agree that this has been a very important and enlightening webinar for all of us. We appreciate you all for taking the time out of your busy schedules to join us for today's BenderU. And final reminder, this session has been recorded. We're gladly going to share a link to the recording and a copy of the slide deck shortly after the webinar has concluded. But thank you again. Please feel free to reach out. We will be including Aaron's information in our follow-up email if you want to connect with him. But thank you again, Aaron, and thank you, everyone. We hope you all have a wonderful day.
Thank you.